Thank you. If, as counsel says, this is fundamentally a case under the Fair Employment and Housing Act, then our work is done. And the reason our work is done is because the Fair Employment and Housing Act specifically says that use of unlawful drugs is not protected. It's in the statute, Government Code Section 12926K6. Physical disability does not include substance use disorders resulting from the current unlawful use of controlled substances or other drugs.
In the use of the term unlawful, is there any reference to any distinction between state and federal, or for that matter, local law?
There is not. It says simply unlawful use. And here, of course, we have use of marijuana, although for medical purposes under California law.
But under California law, and I'm sure that you probably recall some of the dialogue between the bench and counsel earlier, under the law, the legislature of the state of California has decreed it not to be a crime to be using medical marijuana, assuming, of course, that it is prescribed by a physician. So when we talk about unlawful use, obviously, opposing counsel, as you must have heard earlier, has no problem, for instance, with this Court's Loader decision pertaining to unlawful use of unlawful drugs. But as I gather from opposing counsel's argument, the crux of the matter here is not the unlawful use, but the medically authorized use of marijuana to deal with chronic back injuries. Isn't that a distinction? Well, naturally, from your standpoint, being an oral advocate, yes, I too would talk about unlawful drugs, but we have to talk also about the FEHA.
Well, the fact that under certain circumstances there's a defense to a criminal charge of marijuana possession or use does not really address the employment circumstances, nor does it address the fact that marijuana possession and use remains illegal under federal law.
Counsel, how do you address Judge Kosinski's observation that although it may technically be a violation of federal law, as a practical matter, you don't see any prosecutions at the federal level, and therefore it's a theoretical possibility that doesn't deserve much credit?
There are two responses to that. One of them is that although it might be a theoretical possibility, the fact is that an employer remains open to the possibility that its workplace will be disrupted if federal agents come in one day wanting to speak to this employee. The potential for disruption, regardless of whether there might be prosecution, remains. And why should we put ourselves in that position? The second is that, as this Court recognizes in Loader, and we all seem to agree that Loader is a good decision that remains active, the Court identified a host of reasons.
But not relevant to this particular case, it would seem, as opposing counsel has argued.
I beg your pardon, I didn't hear.
I'm sorry for interrupting. Probably just go ahead with your argument. I was just thinking out loud.
I apologize. Simply that the Court has recognized that there are certain workplace costs that are attendant to the social costs that come with use or abuse of controlled substances. And in our view, Loader makes it quite clear that an employer has the right to deal with the potential of those circumstances so that it can have a productive workplace.
Well, opposing counsel, in response to my question with respect to Loader, said yes, but it's not an absolute right. The employer has to take into consideration that the illegal substance or substance that would be illegal if not prescribed by a physician was prescribed by a physician and was necessary for a condition. Why does that not obtain with respect to prescribed marijuana?
Because it's not actually prescribed even under California law. Prescription is defined under the regulations implementing the Controlled Substances Act to have a specific meaning. The Compassionate Use Act in California doesn't speak to prescriptions. It says recommendation. And the Ninth Circuit has recognized that there's a big difference between a prescription and a recommendation. In the Conan case, the Court said, the Ninth Circuit said that if a doctor prescribes marijuana, regardless of California law, that doctor is open to prosecution under the Controlled Substances Act. Whereas if the doctor recommends a patient use marijuana to treat a condition, that's an exercise of free speech rights under the First Amendment. There's a very important distinction.
So it's your position that the compassionate, that FEHA never protects never protects the use of illegal drugs?
I think FEHA says that explicitly.
And how do you then make the leap to this case, since the Compassionate Use Act says it's okay to use it for medical purposes?
It's not a leap, because the Compassionate Use Act says it's a defense to a criminal charge. As many of the justices have observed, the Compassionate Use Act says nothing about the employment relationship. It says nothing about employment practices.